نمی‌دونم. I just spoke to Representative Ladd. He was confused as to the start time of this subcommittee, so he will be here within 10 minutes. Thank you. Mr. Chairman, maybe we get started.
Yeah, I'd like to go ahead and apologize to everybody here. I had my schedule all messed up in my phone. I thought this was afternoon stuff, sort of like we had yesterday in the afternoon and tomorrow. And so I was on my way over to talk with our attorney at DOE, Diana Fenton. So she'll be coming here. So when I was on a school district before, we had what we called the Out to Lunch Award. And I'm very deserving of that. We used to give a wheelbarrow out. We had at the end of the school a wheelbarrow race, and the teacher came running up to me and said, "Where are the wheelbarrows?" And of course, those, you have a kid on their hands and you hold their legs and you go along. So we gave that award every year out. I only got it once during the time I was there, but here I am. Should getting it today. So let's go ahead and look at these bills. We have several on the docket today for school building aid or school building structures. The first one is 295, making school building aid program funds non-lapsing. We've had a lot of discussion on that in the past. Thank you. So was there any discussion prior to this, Representative McGuire, on this?
No,
None.
we did not meet. So.
Neat. Okay.
Well, I mean, maybe you at some previous.
So I think to try to expedite this, I would like to just take 5 minutes here for to have a caucus. Sure. And you may do the same thing unless you know where you are on that one already.
We will do that.
Okay. We'll go across we'll go to one of the little rooms across the way. The rooms, right? There's two of them.
So if they're not busy,
We can use either one, yes, right.
Okay, team.
No, we're going to one of those little rooms over there. The ones on this.
I don't have a copy of that. No.
is go ahead, I'm going to take a motion, and I'm going to take a motion on this one from Representative McGuire.
Thank you, Mr. Chairman. I move House Bill 295 inexpedient to legislate.
And is there a second? Representative Peoples? So for the clerk, motion made by Representative McGuire, second by Representative Peoples. This is in reference to HB
295.
295.
Shall I speak to it?
Yes, would you please?
Okay, just briefly, there are two main reasons. One is the school building aid program has, in general, not been very successful. It creates winners and losers. It's like an all or nothing type of thing. It's very expensive to administer, and so leaving more money in it rather than less, we're going to have to replace it with something else. Basically, is my opinion. Secondly, I'm very much against non-lapsing funds in general. I think each biennium is a new problem for the legislature and in particular the Finance Committee. And so we need to, each legislature has to make its own priorities, and to hamstring future legislators by saying, well, this money is set aside for this and this is for that and so on, the less of that, the better. Thank you, Mr. Chairman.
Does the second have anything further to add?
No, I concur with Dan. Non-lapsing funds are not always the best way.
Is there any further discussion? Representative Fellows?
Yes, I think that this bill is a good idea, and I think it's a very small amount of money that we're talking about here. The fact that, maybe the current distribution mechanism isn't working as well as some would like is probably mostly a function of the fact that there's not enough money available. And in terms of the lapsing issue, this is a very small amount of money that we're going to be talking about that would lapse from one year to the next. And given the fact that the appropriation is so small to begin with, it really, I really think that we should include even those few extra leftover dollars to be available, because we might be able to fund one extra project every year or two.
Further discussion?
Yeah.
Representative Damon?
Thank you, Mr. Chair. I support this bill. I think the districts throughout the state who have benefited from the very limited amount of building aid available would profoundly disagree with the statement that the program's not very successful. There's always room for improvement in how we award funds. I don't think supporting this bill is a hands down statement that the building aid program is perfect, but it is a strong statement that it needs more funds to go forward with effectiveness. And in making the limited amount of quote unquote leftover funds non-lapsing, we are assuring that that limited amount of money that was allocated and appropriated for building aid stays as building aid, which I very vigorously think it should.
Any further discussion?
Thank you, Mr. Chair. I just wanted to vigorously agree with my colleague in her statement that the districts that win are very happy with the program. I just want to remind everybody listening that the vast majority of the districts never get a dollar from this and probably would not consider the program very successful. Thank you.
Yes.
With respect to my colleague from Wyndham, certainly the districts that were not funded are not happy that they're not funded. And they're largely not funded because we don't appropriate enough resources for all the qualified projects to be funded.
Any further discussion? Not seeing any. Madam Clerk, would you please call the roll?
Motion is ITL. Representative McGuire,
Yes.
Representative Cobalt,
Yes.
Representative Peoples,
Yes.
Representative Fellows,
No.
Representative Damon,
No.
Representative Bricky,
No.
and Chairman Ladd.
Yes.
So 4-3, motion passes.
Thank you very much. And we will move on to the other bill, which we have in front of us today. It's HB 366, relative to school building aid for eligible projects. We'll look to Representative Peoples for a motion.
Thank you, Chairman. I would like to make a motion to ITL this bill.
Second.
So we have a motion to ITL 366 made by Representative Peoples and second by Representative McGuire. Does the maker of the motion care to discuss it?
Yes. This bill would be paying bills retroactively for projects that were done in the past. I don't think that's fair to people that are waiting on the list to take money and to allocate it that way. I think we need to be always looking future forward and not try to fix past past issues with projects that may have went forth without going through the program.
Representative McGuire? Further discussion? Representative Fellows?
I'd just like to say that increasing the appropriation from 50 million to 60 million is a really small amount of money, and that, we're just completely underfunding building aid as it is.
Further discussion? Representative Damon?
I would both echo Representative Fellows' acknowledgement that this is a relatively token increase in building aid funds compared to the need. And in regards to the added paragraph B to provide $5 million, which in building projects is a very small amount of money, retroactively, there are multiple districts throughout the state that part of their current fiscal distress is built on the foundation of having had to do building projects during the moratorium on building aid. And the fiscal consequences of that go on for literally decades. It is disrespectful to those districts to not address their needs in any way at all. I wish we could find a way to come together on this bill.
Lastly, I'll say something. I don't think it's disrespectful. We've had this bill come forward here numerous years prior to this. And when this was occurring, it was formed to all our districts that money that's used, you appropriate dollars at your local level and take out a bond, what have you, to use for new construction or renovation without going through the process of applying and doing your site design and all in conjunction with DOE and having that project approved. You're not going to get reimbursed for that type of activity. And so people did it knowingly, and now they're coming back and say, oh, by the way, we're short dollars here in adequacy. We're short dollars in capital costs for our construction now. We're short on career technical education. Yes, we know that. But this is not where, what we appropriate dollars for. We move forward and try to deal with all these issues in front of us. To do this right now, it's water that's under the bridge. Further discussion? Representative Fellows.
Yeah, I'd just like to say that one of the reasons that we got to this point is that if you look back, I don't know, maybe 15 years ago, that the formula for building aid was very different. It was different than it is now. And it combined it gave you two options under which you might qualify for building aid, and districts could pick the one that they wanted. And I believe the situation was that the state funded a certain percent of projects, and there was no cap on it, and that caused the state needing to do a bond to cover those payments. So it's not the school district's fault that we're in this situation with this building aid and not enough money. It's really the legislators' fault for not anticipating what was going to happen. And what happened was that at one point the interest rates were so low that lots of schools wanted to do a project at the same time. And that's how we got to this. And it's really not to be blamed on the school districts.
Further discussion, Representative Damon?
Thank you. I just want to acknowledge one more very significant reality in school districts who did a building project during the moratorium on building aid. They were doing those projects in crisis. In Claremont, for example, they lost accreditation and they couldn't get accreditation back without renovating the very, very old high school. It wasn't frivolous, it wasn't extravagant, it was essential. And so asking to provide a small part of the funding of that project that would have been funded then if we didn't have a moratorium, I feel very confident of that. It just seems to make a great deal of sense to me.
Any further discussion? Not seeing, Madam Clerk, would you please call the roll?
Motion ITL, Representative McGuire,
Yes.
Representative Kofalt,
Yes.
Representative Peoples,
Yes.
Representative Fellows,
No.
Representative Damon,
No.
Representative Bricky,
No.
Chairman Ladd.
Yes.
Motion passes 3-4-3.
Okay, so on both of these bills, this bill, fails with an ITL, with a 4-3 vote. We will be presenting this recommendation to the full committee when we meet next. And just for the folks that are here, in terms of when we meet next, it's scheduled for November 4. That date's probably going to be changed due to the fact that cities are also meeting on elections. And now we've had 1, 2, 3 people that I know of that cannot make it. I know that one of our members sitting here has tried to juggle a schedule to be here, but we're going to have to change that. And it'll probably go into the next week, most likely on a Wednesday or Thursday of that next week following.
So the 12th or
after the
13th.
11th, after the 11th, to 12th or the 13th.
Right.
I will get that resolved today.
Thank you.
You're welcome.
Shall we write blurbs for this bill?
Well, what we're going to be doing is there's no blurb that's handed out. We make a recommendation to the full committee, and then that's when the blurb will be written.
Sure.
So how is that recommendation made to the committee? Is it just verbal?
It comes from the chair of the subcommittee to the chair, which happens to be myself to myself in this particular case, where the recommendation of the subcommittee is, that, and there can be some discussion of it at that time. There will be, of course. And that's where we will make that final decision and write the blurbs, the minority and the majority blurbs.
I just have a question about the date change.
Yeah.
Do you have any idea what it would get changed
We
to
just said the 12th.
The 12th or the 13th,
of November?
yes.
Okay. Okay.
Okay, we have 3 people that come from cities here, I think, on the committee. And even though you're not running for a position, you might be wanting to hold
Of course. Yeah.
some kind of poll.
No, it makes sense.
Yeah, okay, so we're done this subcommittee meeting. Yeah,
I just got a text saying that there's usually a subcommittee form to fill out. No? I don't know, but I'm just clarifying.
I don't have one in front of us here. I've never had one before. I've never had one before. It's subcommittees, sometimes the subcommittees come up with no recommendation too, and it just goes back to the committee of the whole to make the decision.
Okay.
Yeah,
We did not do
yeah,
that.
yeah.
And absolutely, we're not meeting on the 4th. Right?
Absolutely, right now, yeah. Yeah, we have people that are just not going to be here beyond what I already knew.
I was just saying, I'm volunteering to write a blurb for 295 if you want me to. That's the, so
So what's the,
We know, you know where we're going.
I think so.
we're way behind.
Yeah,
Shall I? Or no?
off the side, yeah.
Okay, yeah.
Yeah.
When it's next.
No,
Deadline,
It was
Our
close.
deadline for.
I hope the cover was on. Oh,
Special ed.
Yeah.
where's the,
Excellent.
we don't have, that's too bad.
Have you people made any kind of decision that we're going this next one on catastrophic aid now that we have the commission study going on? And that's probably the ones for the recommendation on catastrophic aid.
11:30?
Wait, this is the wrong one. 1 second.
When I talked to Dave last night or yesterday, we were of the opinion that with the Special Education Commission currently engaged, and we've met one several times already, and we will be issuing a report November 1 of right now, this year, and another one November
So the
1
commission is doing a November 1 report?
for the two meetings we've had to date. Yeah, it will just explain, we have heard from Lippman, we've done this, we've handed out this materials. We have coming in, the issue dealing with charter school special education and EFA special education. We need to get more specifics out of the department in terms of, how we're intervening to deal with the increased IEPs that we're having. What's the nature of IEPs in various schools and school districts? Are there some districts which are, where the percentage is well above the 20%, 21% of our ADMR? Or are there some that are lower? We got to get all this information and then ask why are they where they are? And when I talked to Melissa White, she's saying there is some over-identification going on. And I think we all know that. When back, 15 years ago, we had roughly around 30 point something thousand kids with IEPs. Now we have 31 point something thousand, and our population has just gone down. So there's a higher percentage of our ADMR that's now labeled IEP. Why? And then how do we cost it out is the big issue. How do we cost it? What's the formula going to be? Those are issues that have to be resolved. I don't think we're going to do it during a subcommittee here. And I don't think that bill does it either. We made changes to catastrophic aid this last go around. Changed the proration amount to 80% rather than 68%. And if there's not enough money, you go back to the general fund, you get that money to make sure it's 80%. That's what we did. We didn't change the 3.5 or the 10 times per pupil at all. We left that the same. And the reason why we couldn't change it, we don't have the data to know what it means to go to 2.5 or 2 times, rather than 70,000 going down to 60 or $50,000. We have no idea, and nor this department. So I don't know where we're going to go with this subcommittee if we always have a commission with directors on and all doing the same thing.
The hard part, there's no data to
Yeah,
figure out.
I absolutely agree with the need for a great deal more data. I also have a concern that if we don't take any action.
Oh, I think what
I don't
we,
mean not take any action. If we don't do anything to address special ed funding as the committee and we wait for the commission.
oh, we're going to.
outcomes.
There are bills coming in that are addressing it, changing the formula.
It will be discussed extensively.
It would be
Bills
discussed,
coming in for 2026.
LSR, right
So
now.
those bills, all right, so then I'm puzzled if it feels like on the one hand, it's being suggested that we wait for the commission reporting, which clearly will be much more complete.
Well, what we
a year
could
from
do,
now
we don't
than
have to
a year
kill
from then.
this. We can interim study it and be studying at the same time currently, concurrent with the other, but it's just going to be just duplicating the effort.
So is it just the two of us? Let's go caucus. Can we caucus for a minute?
Yeah.
Oh, what?
Special ed.
Is that?
Are you not? Yeah. Are you not?
You
on special ed?
might give Dave a call.
Yeah, I'm gonna do that.
because we talked about it the other night, and I think the best thing to do is recommend interim study on it and move forward. Diana, do you have a second? Okay,
We're gonna go back in there.
I think we're ready to go ahead here on HB 742. 742 is a bill requiring catastrophic special education state aid funding to be drawn from the Education Trust Fund. And for the meeting today, Representative Spilsbury is on a plane headed for Utah. So Representative Popovich, you will, be in his place today.
Thank you, Mr. Chair.
And so I think we have all members here then. And let's go ahead and have a brief discussion on this bill. It's very similar to where we were in changing some of the manners in which we're dealing with proration and all that we did in this last year. And if money's not available, you go to the Education Trust Fund, and if the balance in the Education Trust Fund is not, you go to the general fund to obtain that money to make sure you get to that 80% level on the proration. That was passed last year. The issue that I'm dealing with or groping with is that we now have this bill as a retained bill. We have the subcommittee going on and having to make a recommendation here shortly. And then we also have the Commission for the Study of the Costing of Special Education going on concurrently. And the Commission for the Study of the Costing of the Special Education has some very specific duties listed within it, 9 or 10 of them. And we also know that there is legislation that has been submitted for this upcoming year, which are dealing with the issue of the shortfall we had with special education aid in the last year, where we allocated $34 million in our budget, and we came up $16 million shy. Also dealing with the formula in regard to differentiated aid, where differentiated aid, when it comes to special education aid, which is not targeted, but it's identified as special education aid, amounts to $68 million in FY26. $68 million. And we know that, and I've mentioned it before in the commission and previous meetings of this, that the total cost of special education, as you see in the one of the papers is just yesterday, in Union Leader, there's reference to the cost of special education, how it's driving school districts trying to find out where is the money coming from, and the knowledge that 1 out of every $4 we're spending in education in this state are now related to special education. $68 million comes from the differentiated aid. $50 million comes from federal aid, IDEA, and approximately another $34 million to $50 million was $34 million was appropriated for the catastrophic aid, special education aid, up to, I believe it's up to $50 million roughly this coming the biennium we approved the budget for. It means that 85% of the costs of special education are being assumed by local school districts. Now, why are these costs skyrocketing? That's one of the issues before the commission right now. Why are we seeing more students with IEPs now than we did 10, 15 years ago when you look at the percentage of the average daily membership in residence or attendance? It's reflecting that we have more kids with the IEPs now, percentage-wise of the whole, than we did back then. And it's pretty much a significant increase. And we see certain IEP categories which are growing and have doubled the number of students which are in those categories. There's much to be discussed and much to be researched. And we also have been unable to get any data regarding the students which are below 3.5 times X, 3.5 times the average pupil cost, that's the mark you have to meet to become eligible for the special education aid. We do not know if we're taking advantage of the Medicaid monies which are available even prior to that. We've met with Henry Lipman. We've had him in subcommittees. We've had him in the commission study and looking at how we can get some assistance and support in applying for this money. So there's much to be done. My druthers right now is with the commission study, and the commission task and membership involves people from various organizations and knowledgeable people that are coming in as either from the department. There's a business administrator that's from this local school districts who's very knowledgeable. We have a person sitting in the room right now that's appointed by myself to be on the committee. We have directors on the committee which have been bringing in and answering some of the questions. We have the director of special education on it. And so I think that commission personally is the way for us to be going rather than doing something with this right now when this doesn't really get down and resolve the issues that we have before us. So I'll open it up for a discussion right now. And Representative Popovich.
Thank you, Mr. Chair. I just want to bring two things up. One of them, you mentioned an increase in the percentage of the kids over the last 10 to 12 years. I actually ran the numbers earlier this year because we had so many bills related to this topic, and the percentage of children that receive special education services has increased by 25% in the last 4 years. We are not talking about a decade. We're talking about 4 years, 25%. And every time I ask why the increase is there, what happens, what drives it, every answer I got was, I don't know. It just happened. So I think we really, really need to understand what is the reason why this is happening. And I don't think we have the data. Second, I would like to point out that this particular bill, 742, is attempting to deal with a cap by removing it altogether. I want to remind everybody that we changed the proration by limiting the amount of proration that's possible, therefore allowing schools to know that they have a certain amount of guaranteed reimbursement. So to me, the good parts of this bill have already become law through the budget. So I would not see a reason to continue, with this bill going forward. Thank you.
And just make a quick comment in regard to what I just heard, that there are a number of possible answers to why the percentage is increasing. Our society, better identification, better intervention. Those are all very good questions, but need really more digging down deep into and finding out, is it, over-identification or is it better identification? Or is it both? There's a lot to this, and that's why I believe that the way we're going to get some of these answers is by having the knowledgeable people we have on that commission and move forward with that information and do some good research in between. Yes, Representative Bricky.
I do agree that there is much data about special ed that is still needed, but this bill is about where the special ed aid money comes from, not about the formula or how to decide how much money a district will get. Regardless of the amount of money, where it comes from should be easy enough for us to agree on, and it should come from the Education Trust Fund. And that's really what this bill is all about, not having to compete with other programs or needs in the general fund. So I believe that, and sending this interim study, and I totally am looking forward to any answers that come out of, I didn't even have that on, sorry. I totally look forward to any answers that come out of the commission. But even with those answers, that just puts it off for another year, 2 years. So this is about the money, not about why special ed is increasing, not about why more people are being identified. This is about the money, and I think that we can agree that it should come from the Education Trust Fund. Thank you.
Further discussion, Representative Popovich.
Very briefly, I think we already agreed on that in the budget. I think that in the budget currently, the money for this is coming from the trust fund. If I'm wrong, I'm more than happy to be corrected. I think that the only leftover parts of this bill that are not part of the budget is that it attempts to take any proration out while the current budget limits the proration to a certain amount.
Representative Damon?
So several things. The bill that we passed last year caps the proration. It makes it predictable that districts will get at least 80%. But the statute says that the state would pay when the needs of the child are 3.5 times the state average expenditure per pupil. So the fact that we prorate it at all, to me, is a violation of what we should be doing when this is really a fairly small number of students who have extremely expensive needs. We should really be helping districts address them. I would echo the chair's observation that we do know some of the reasons, maybe not with as much quantitative specifics as we'd like to, but we do know some of the reasons for the increase in identification of kids who need special ed services. COVID, addiction, I would add food insecurity. Chronically being underfed is not good for brain or behavior. It definitely affects cognitive function and learning capabilities. When we talk about the increase in incidence of students receiving SPED services, we could frame it in a different way than saying, why is it so much more? We could say, why was it so much less before? And I'm not trying to do a word game. We weren't identifying a lot of kids who can benefit and learn and become productive. In the past, we didn't have as much expertise to identify, and we didn't have as much skill set to help them. There's been a lot of growth and learning in special education, and I think it's important to acknowledge that. And relative to Representative Popovici, I'm not sure, so I too could be corrected. But I think in the budget, it does come from the Education Trust Fund, but isn't that only for this current biennium? It's not putting it into statute that special ed funding come from the Education Trust funding fund. Is that correct?
That is correct. And I will also add really quickly that I did look up HB2 and it is definitely appropriated from the Education Trust Fund. I wasn't sure before. Memory is one thing, checking is another. But I would like to point out that it is quite unlikely that we are going to change that policy in the next budget, and also, frankly, passing a bill that makes it otherwise will still be subject to the next budget process. At the end of the day, there is not a meaningful difference in that particular source, because this is a budget issue every year, right? And the mechanism used doesn't really make a difference, whether it's HB2 or a separate law or a separate bill. The outcome is really the same. So,
Further discussion? Okay, so what we got to do now is we're going to move into taking some action on this bill. I'm going to just have a 1-minute caucus on this so that we can figure out where we're going. I can assure you that I'm looking only at this point in time at 2 possible motions, and that's interim study or ITL. And my rationale is that there is a special ed costing study going on right now, which is a commission study, which I think is more thorough than what we can do as a subcommittee.
When is the report due for that committee?
That report provides their initial report on November 1, and then November 1 of the following year, the final report is issued. So it's issued so that legislation can be done during that next biennium. I'm sure, though, that there will be, along the way, specific findings which are released, and that on the other side too, we do have LSR in place right now. It's modeled pretty much after what's going on down in Arkansas, with their study of how they do it in terms of proration. The research shows that many states are having, due to the extensive costs associated with the special education, that proration is occurring with all their formulas. And you'll find that even within some of the states within New England here. I do have that information not in front of me today, but proration is something that's going to go on as long as these costs continue to skyrocket the way they are. And when we're up to $977 million per year for special education, which 85% of that is a local cost, we need to take some action. And it's changing this proration is not going to deal with the growing costs and how we're addressing that. And so I think that it's important. So we're going to take a 1-minute caucus here to figure out whether we come forward with one of the two motions that I just mentioned. So let's just hop out across the hallway. Okay, we're going to go ahead and wrap up 742. HB 742 is requiring catastrophic special education state aid funding to be drawn from the Education Trust Fund. And I look to Representative Peoples to make a motion.
Chairman Ladd, I'd like to make a motion to interim study this.
Second,
Is there a second?
second,
Representative Popovich. So we have a motion on the table made by Representative Peoples to interim study 742 and second by Representative Popovich. Further discussion from the maker of the motions?
In light of everything we have going on with the commission and the other bills that are floating around, I'd like to keep this alive so that we can maybe use it as a vehicle in the future here to help address some of these problems that we're hoping to identify with the commission. So that was why I would like to interim study it rather than ITL.
Thank you. Representative Popovich?
I completely agree, and frankly, we will continue to work on this for as long as we are a committee. So I think it's good to have, a bill to work with.
Thank you. Further discussion from the committee? Representative Damon?
Thank you. I appreciate the motion being interim study as opposed to ITL. And at the same time, I find it an inadequate motion because I think we know that interim study a bill in the second year of the biennium, it's probably just sitting on the shelf. It is critical to our school districts that we address the special education funding needs. And so while this is most definitely not a perfect bill, it does a couple of good things, and I will be voting against the interim study.
Further discussion from the subcommittee members? Not seeing any. Madam Clerk, would you please call the roll?
Representative Popovich,
Aye.
Representative Peoples,
Yes.
Representative Damon,
No.
Representative Bricky,
No,
Chairman Ladd,
Yes.
3-2 passes.
Okay, so we will be keeping 742 on interim study and making that recommendation to the full committee come either November 12th or 13th, whatever date we set for that meeting. So this concludes the subcommittee work on 742, and we're going to take about 2 minutes here, and then we're going to start right into the next set of bills, which are the higher education bills. Higher education, we have Ladd, Ritchie, Brown, and Luno, and Burton. And I would assume that, are you taking, I'm sorry, are you taking Dave or is it Representative?
I am.
Tracy's Dave.
Okay, so
I use it to relocate.
Right.
Because it's
so we're gonna start up here in a second.
Wayne.
Yeah. Okay.
Let's see.
Well, then it's gonna have to be. County meeting. How many other people are? Oh, yeah,
Yeah.
So the Merrimack County meeting on
The 13th in the morning.
in the morning, so,
That's Thursday, right?
yes.
Could do it in the afternoon, but it is Merrimack County. But still, it's Merrimack County. So there are gonna be people who can miss it.
If only one person is affected, it's still new.
Yeah, 12 might be better, I don't know.
12th is not better for me.
Okay, so,
I already have 2 meetings on the 12th in the
Okay.
morning. One in the morning, one in the afternoon.
okay, the Thursday in the afternoon though looks good.
Thursday in the afternoon looks good.
Oh, come on, we should have done a Wednesday lunch. We couldn't take. I'm not touching anybody's lunch.
We're going to continue here. We have the subcommittee work here on 3 bills which are relative to higher education. HB 443, HB 510, and HB 112. We're going to just take them in the order that they're listed here on the sheet. HB 443 is relative to terms of appointments members on the Higher Education Commission. This bill was put in by the department and looking at the Higher Education Commission and how members are appointed. And I've since talked to the Director Appleby over at the department. He said the issues that they had put in for have been resolved. We don't need the bill. So my recommendation for folks right here is that ITL 443. So, but I'm going to put that out for discussion first and have any input from folks on the subcommittee. Basically, it says the terms of appointment of members, except as otherwise indicated above, shall be for 5 years and until a successor is appointed and qualified. In other words, if somebody doesn't come to those meetings, if somebody's no longer representing that particular group, as the governor's office sees it right now, they're done. And they're going to be replaced. So there's no need for this particular bill.
You take a motion?
Yeah, I'll take a motion.
Inexpedient to legislate.
Okay. We have a motion that's been
Second.
We have a motion that's been put forward by Representative Burton and second by Representative Popovich. And the motion is ITL inexpedient to legislate. Is there any further discussion? Not seeing any. Who is clerking this one?
I am.
Okay. Representative Brown, would you please take the roll?
Representative Brown, yes. Representative Popovich,
Yes.
Representative Burton,
Yes.
Representative Bricky,
Yes.
and Chairman Ladd,
Yes.
6-0.
Okay, I'm sure Mr. Appleby will be very pleased. So that,
5-0.
pardon me?
5.
5-0.
Did I
yes.
say 6?
5, yeah.
Do you have to move to second?
That's that modern math.
I'm using base 8.
No, we're just making recommendations to the committee of the whole, which will act on this when we meet next, which will most likely be on November the 12th in the afternoon, starting at 1 o'clock. So, and change from November 4th. We have not got that in the calendar, nor has anything officially been done on that yet. Okay, the next bill we have coming up is 510. HB 510, relative to establishing certain due process rights for students, student organizations, faculty members facing disciplinary actions by state institutions of higher learning. Let me get my workout here. Okay, since we have met previously or done any work on these bills as a committee, as a committee, a large committee, and then retained, I've taken a second look at a letter which we've received, not a letter, but a communication that came to us in hearing. And it was signed by Catherine Provencher and Lauren Banker. And it's from the university. I had an area where it states, the bill states that all students, student organizations, or faculty members shall be provided the right to confront and cross-examine witnesses who provide evidence against a student, student organization, or faculty member. Currently, Title IX allows cross-examination, but it must be done by an advisor. As the bill is written, a student accused of sexual assault could directly confront and question the impacted party, parentheses, victim or survivor. This practice will create a substantial chilling effect on the likelihood of future parties bringing reports and participating in resolution process. I've, given this a great deal of thought here, and I believe that this subcommittee has to do the same. There are some other places within the bill which we have caught, and we talked about the definitions of student organization, and faculty member, and we looked at what we had done previously with another bill, which is now law, and saw that definitions were different. And so there is an amendment which we also have to reflect the language that's currently in statute defining student organization, or faculty. And I think we all saw this the last time we met, and that amendment, I have here a copy of it, if I can just dig through all the paperwork that's been dropped here. Well. So that's, I'll find it's under all the paperwork here somewhere, but I will find that. So what I want to do is first open this up to discussion. And the point I'm asking, are we ready to take action on this bill right now? Or do we need some clarification on Title IX, the definition of advisor? Is the advisor appointed by the university system, or is the advisor a person that is there supporting the individual that's been allegedly accused of committing the act and confronting, cross-examining the individual who is the recipient of the occurrence? So let's open that up to discussion and see where we are on it. Yes, Representative Burton.
I've listened to testimony in this bill at least twice. And with all due respect to the sponsor, not once has he offered a reason why this is needed. I asked him directly that question during the hearing we had, and he didn't answer it. I mean, we have enough problems addressing with bills problems that exist where the sponsors have a concern they want addressed. But in this case, the sponsor of the bill has not ever, in my listening to him, said why it's needed. And to me, we've got enough legislation that is needed. Why would we work on this one?
Okay. Further discussion, Representative Bricky?
We heard quite a bit of testimony last time we met on this, and the overall consensus seemed to be that due process is already working on campus, that we haven't had any complaints. So this looks like a bill that's looking for a problem instead of a problem being addressed.
Further discussion, Representative Popovich?
Thank you. I'm not the prime sponsor, but as a co-sponsor, I will state that there are significant concerns about how the process is currently running, because people are accused of terrible things, and I'm sure some of them have committed such acts. But in the process of finding out who's guilty and who's not, there are some basic rules, one of the most essential of which is that we should be able to cross-examine a prosecution witness if you're a defendant, or you should be able to cross-examine a defense witness if you are the victim. And as of now, this is not ensured, because any such cross-examination is being done, as far as I understand, by an administrator who's, representing neither of the two people, or somehow magically represents both of them at the same time. And that creates huge issues in terms of the validity of such examination. If our facts are not vigorously explored, it's very hard to make the correct determination. Thank you.
I'm a little confused on it in terms of who is the advisor? Who appoints the advisor? Is the advisor at the selection of the individual that's being, that is allegedly guilty or whatever we want to call, I'm not an attorney, of this act, or by the university is appointed there, or is it somebody that is representing that person? Catherine Provencher, do you have any answer to that?
Don't know the details. I'm not sure if I'm going to hear back from them right now, but I don't know who would appoint the advisor, how they're chosen, what the role is.
Yeah.
If I may ask.
Yes.
If I may ask a follow-up question while we are doing research, could you clarify whether each side has a advisor representing them, or is it a single advisor juggling everything? Because my understanding, it's a single person who's basically acting as a go-between, but I would really want to make sure that we have our facts straight rather than, kind of hoping we're right.
If in fact we tend to move forward with this, I have some language which I'd like to add, which kind of reflects some of the language which I see in that report or that we heard, which was presented by the university system. And there's on page 2, line 19, item E, it states, the right to confront and cross-examine witnesses who provide evidence against a student, student organization, or faculty member. Then I add in another sentence following that. In matters of sex-based discrimination, sexual harassment, sexual misconduct, or other provisions pursuant to Title IX of the Education Amendments of 1972, the Violence Against Women Act, and institution policy, the right to confront and cross-examination must be done by an advisor.
If I may.
Yes, Representative Popovich.
Just very quickly, my first, I never heard that before, right? So my first reaction to that would be that we probably want to extend that to a lot of other serious, accusations. I don't know if that definition is broad enough. But again, I want to remind you that one of the issues is that one person, one advisor cannot represent effectively two opposing parties. And I believe that there are other people who would like to speak.
Representative Damon,
I'm not on the subcommittee, but I'd like to speak.
go ahead.
Thank you. So in regards to the inquiry about the advisor and whether they, who are they representing? If you read page 2 at the top, lines 2 through 4, it talks about the student organization or faculty member being entitled to the following, and then the alphabet order, and comes down to H. So they're entitled to the assistance of. So it's the person who the disciplinary proceedings have been filed against, in this language here, is entitled to an advisor. And in H, it says, such advisor, advocate, or legal representative shall not serve in any other role in connection with the proceedings. So they can't represent both parties. There was some question about that, I thought.
Yeah.
And then before I yield the mic, can we get a copy of the language that you have, Mr. Chair?
I only have one copy here in front of me because I'll pass down, and can you hand it back to me after you read it?
Of course.
I took that language to the Legislative Services yesterday evening, and they indicated that's a start, but there's a lot to this. This is why earlier Diana Fenton was here. She's one of the attorneys over at Department of Education. And I worked with her previously on not similar type stuff, but worked with the department when we dealt with some issues which occurred up at Dartmouth College. And I I am concerned that we make sure that what we do is going to be done correctly if we do something. And I want to make sure that it's going to try to do it so thoroughly that we don't end up the minute we pass something in litigation. And so I'm concerned that whether you're the complainant or the respondent, and the complainant is the one that's allegedly been hurt, and the respondent is the one that's going to be doing the cross-examination. I would certainly understand that advisor would be representing either one of those parties and not necessarily being appointed by the university system or the community college system to do the questioning on both parts. I don't think that would work. I think that, but I also do not want to really doing something which is contrary to Title IX. I've been a very strong advocate of Title IX when it's come to other activities for women's athletics, and sport. So here again, I want to do it right. I do not expect to take any action on anything here today. I think that there's some questions which need to be answered. So Representative Popovich, did you have your hand up earlier?
Yes, I did. I just wanted to address what Representative Damon was saying earlier about, the advisor definition. Mm-hmm. The questions that we were asking of Ms. Provencher are about the current system, not about the bill itself. I think that's where we may have miscommunicated a little. So we want to see how things are now, not how we are proposing them to be in the bill. So,
Representative Burton?
I just want to point out something that's important. I was a dean and college president for many years, and I've been at UNH, and I'm on the Durham Town Council. Any serious crimes that occur in Durham are handled by the civil authorities. I've ridden with the police in Durham on a Saturday night, like for instance, when there was a demonstration against the war in Gaza, the student demonstrators were arrested by the civil police and tried in Stratford County Court. And my guess is that if someone were arrested for a felonious sexual assault, that's the same thing would happen. They'd be put in jail in Stratford County, and they'd be charged by the county attorney. So any serious crimes that occur in Durham or Plymouth or Keene would be turned over to civil authorities, and they'd be entitled to all the rights that someone gets when they're charged that way.
Representative Popovich?
I know we are eating into lunchtime, so I want to be very brief. I would like to know if, in the opinion of my colleagues, there are situations when somebody is accused of, say, sexual assault on campus and gets administrative punishment, but does not get referred for a crime. So they never get an opportunity to go through court. What happens to those people? Because I'm pretty sure that you'll never see a complete overlap of everything we do in these proceedings versus what happens in a criminal court. So what happens to the people who, for whatever reason, the PD is not interested in prosecuting, but the university suspends? How are their rights protected?
Can I answer that?
Representative Burton?
It depends on what they do. I was threatened with suspension when I was a student once. The college or the university has to have some rules of conduct. And if those rules of conduct, and it's clear that if you do these things, then you could be suspended from the college. Now, whether the civil authorities would come after you or not, I don't know. But we have 12,000 people between 18 and 22 in my town. Okay, what parent in their right mind would ever send their kid to a place where there's 13,000 other young people? We have on campus there, we watch the adolescents happen. And the university itself, I've sat on boards, try to judge whether a student's conduct is such that they might do harm to themselves or somebody else and need to sit out for a semester, for example. It's an unusual situation in Keene, Plymouth, and Durham. And I'm convinced that we used to overdo it when I was an assistant dean at the business school, to make sure that the students' rights were accommodated, but yet whatever the result of the process was reasonable. And sometimes it was separation from the school for a semester or a year or forever until they grew up. Because unlike myself, who was very mature in college thought, that happens. Thank you.
You know, it's a situation that I think we've all been in college, and we've all gone through a lot of that. At least I have. But, you know, the issue is that boys will be boys, yes, but, you know, are there two standards? A standard for on campus, a standard for off campus. If you're, you know, and I've seen that with another situation in this state, and it seems like there's two sets at times, two sets of standard. I don't know. I'm not ready to go forward with this bill at this time until we get some answers to the questions of advisor, to get answers regarding what is the confidentiality of background information of the person that's the complainant. I don't know how to define advisor, and I think that should be defined. So if there's anything else that we can offer right now, I think we need to put it on the table and trying to get some resolution here to whether we're going to move forward with this bill or not. Is there anything else at this time? Not seeing anything from folks right here on 510. There was one amendment. Have people seen the amendment that we had for definitions?
You mean different from the one that you just circulated?
No, that's an amendment we're not doing. That's not an amendment yet. This is an amendment right here that we had talked about. I only have that one copy, but it's an amendment which defines student, it defines student organization, and it defines faculty in terms of what's already in statute. It says student pursuant to RSA, blah, blah, blah. Faculty pursuant to, student organization pursuant to. Representative Popovich?
Could we have a copy of that distributed to everybody? Because even though I know what the amendment wants to do, I really want to see the language before I vote on anything.
Yeah.
I don't remember seeing that at the last time we met.
We talked about it at our last meeting.
We did? I don't
We did
remember that.
discuss it.
I don't even have that
Was
in my notes.
Representative Luno here at that time?
No, I have 923. The last time we met was 923, correct?
I do, so if I may.
Yes.
We did not discuss the specific language of an amendment. The discussion was about the need to synchronize the definitions in different parts of the chapters. And, the prime sponsor indicated that he would be very supportive of such an effort, but we did not speak about the specific language. So that language we'll see now, but we discussed about the intent and the value of it.
Okay, thank you.
A quick comment.
Yeah.
I just want to point out that the Durham Town Council, on our agenda, every meeting, has the president of the UNH student body come and speak. And in my 11 years on the council, none of them have ever complained about due process. And many of them were women. And you'd be proud to be their parent, I can tell you that. But it's never been reported to the town that this is an issue. Thank you.
Yes, Representative Bricky?
So, thank you. So it's my understanding that we have to have all of our committee work
subcommittee work done by November 1st. So if we were to say we're not going
Well,
to,
it doesn't have to be done by November 1st, but we have to have our reports by the whole committee. It's the 21st of November. So we have to have this all done by the 21st from the Education Funding Committee.
okay, so if we're gonna meet on the 12th or the 13th, this has to be figured out by the 12th or the 13th, so we would have to meet again.
Right, exactly. Or meet early on the 12th. But, you said you couldn't meet in the morning.
I can't really meet at all on the 12th. I have a meeting
Or
in the morning.
is it the 13th?
The 13th is, yeah, I'm pretty sure that's what it was. I have a meeting on the 12th, I have a meeting in Laconia in the morning and then in Plymouth in the afternoon.
So when was Merrimack going to meet?
Thursday morning. Merrimack County was meeting Thursday morning.
Yeah, so that's the 13th.
That's the 13th.
And the afternoon is when we were going to have our meeting.
Oh, the afternoon of the 13th.
Yeah,
That sounds good.
yeah. No,
If not, I mean, just because I can't be here, I can,
I understand.
but you really can't operate without me.
Okay, but the language for the definitions, that came out of HB 1305, which was adopted back in 2024 session, and it's now law. And so the definition of student means any person who is enrolled on a full-time or part-time basis in a public institution of higher education, period. That's what student is in law right now. Student organization, as in law right now, says student organization means an officially recognized group at a public institution of higher education or a group seeking official recognition comprised of admitted students that receive or are seeking to receive benefits through the public institution of higher education. That's in law. And the other definition which we had, I believe, was public institution of higher education. Is that the other one on that sheet? And that means any public technical institute, public junior college, public senior college or university, law school, medical or dental school, public state college, or other agency of higher education as defined in state law. That's in statute right now. And so what we are doing is plugging these definitions that are in statute into this bill. This bill was much different, not much, but it was tweaked differently on all those definitions than we have in law. We felt that we shouldn't have different definitions in different parts of statute. So that's why that amendment was put together. It's kind of a technical correction. It doesn't address the whole bill. So what I'm trying to do is see if this is good enough right there, that if this thing were to move forward, would we want to have the same definitions in there? And I would think yes would be the answer in that, but everybody has a ability to say the opposite if they want. So then what we got to do is get some answers to the other questions which we've had today. Advisor, who appoints the advisor? How is confidential information handled? And we have some people reaching out right now to try and get us some answers on that. So I don't think we can take action on this bill today. Yes, Representative Popovich.
Given that we have to meet again, even though I would suggest that maybe if everybody agrees that the amendment is a good amendment, regardless of whether they support the bill or not, we may as well get it out of the way. But otherwise, we could wait until we make the final disposition of the bill and take care of it.
We can go at either place. Is there any support in taking action on the definitions right now? Yeah. Why don't you just put a motion forward then?
Then I would like to, if I may, make a motion to adopt, to recommend the adoption of Amendment 2025-3009H for HB 5110.
Is there a second?
I'll second that.
Okay, so we have a motion made by Representative Popovich, second by Representative Bricky, to move Amendment 3009H to amend HB 510. Any further discussion? All those in favor? Aye. Any opposed? Okay, so it's Representative Brown, it's unanimous. So we got that one taken care of. So what we need to do is we need to set a date for coming back. And one more time, I would like to have at least a week and a half to try and gather the research that we need. So we're sliding in towards the front side of November. So I hate coming down here all the time for a separate meeting.
On the 10th,
Yeah,
we have CTE from 11 to 1. So I don't know if that,
we meaning you and I,
yeah, you and me.
you and me. Let's see what I got here.
I was just saying that because that means you'll be here.
Oh.
In this general area, anyway.
On the,
10th.
yes, yep. Okay, okay, Catherine Fincher, University System, welcome.
Thank you. Good afternoon, Mr. Chair, members of the committee. Relative to advisors, according to the UNH Assistant Dean of Community Standards, Policy and Compliance, typically parties have the right to an advisor of their choosing. If the party has opted not to exercise this right, the Title IX coordinator will appoint an advisor for the purpose of cross-examination during a proceeding. So the same advisor would not serve on both sides. I don't have an answer yet on confidentiality. I know that was one of your questions.
Representative Popovich?
I apologize for asking questions in stages. I should have thought of the extension, the question I'm asking now earlier. Does that advisor come from anywhere, or is it limited to a university employee, administrator, and so on? So basically, what's the pool of eligible advisors for that? And as I said, I should have anticipated and asked the question earlier. My apologies.
I'll need to get some more information for you, so I'll add that to the material.
Are there any other questions for Catherine Provencher? She's already out of here. Okay, we're good. Thank you. So, okay, going back to the date on the 10th, yes, I do have a meeting at 11 o'clock. Is that at 11 o'clock? Is that
11,
one?
yes.
Yeah. So we could meet, that's at Granite State College, right?
Yeah,
So is the morning good at 9:30? 9:30 to 10:30? For folks, if we were to,
you think it should be 9?
pardon me?
You think it should be 9?
Oh, we could meet at 9, yeah. It's,
What, I mean, I just don't know, like, how long do you think it'll take? Yeah, okay.
well, it could, you know, if, you know, like, Attorney Fenton's also contacting people in Boston on Title IX, so we
So it
could, yeah,
could go quick, or it could go, yeah.
yep. It could go, yep. So I can start at 9 o'clock if that's good for everybody else. It's not too early for folks to drive. Okay, so let's set it at 9 o'clock. Rev's name in here, you got that quirky little smile.
It's Monday morning.
It's Monday morning, that's right. And of course, we fall back this weekend coming.
Yeah.
So we'll be used to it by
Well, we should be used to it. Okay. So we will meet then on the 10th at 9 o'clock. Yeah. Okay, so that will conclude our work today on 510. Now we have HB 212. This is the civics bill. Yeah, yes, Representative Popovich.
In the interest of saving time, because it's 12:43 and I believe we have a 1 p.m.
We do?
Or I do, oh, well, it's on my calendar. I have a 1 p.m. Since we are meeting again on November 10, given that we may still want to tweak a little that particular bill, maybe we can, do our tweaks and discuss it at that time too. It should still be reasonably quick because again, it's mostly an executive session.
Yeah, we could do that. 510 is going to take a little bit of discussion here in terms of where we're going with the immigration citizenship test. Whether we're going to use that as the qualifier, saying, if you have a familiarity with the foundations of our country, the Constitution, Declaration of Independence, etc., amending language, or is there, I just got to ask the question, is that where are we going and what are we trying to ask the university system and community college system to accomplish, and how are they going to do it? Is there going to be any cost that associated with this? We've heard the sponsor of the bill saying that the cost is greatly exaggerated, but there's going to be some cost. There's going to have to be cost if you're going to be tracking and managing and administering this program. But I'm just questioning whether this is the best way to ensure that incoming students have a grasp of the responsibilities of being a citizen. And I know that in this state, all high school kids take the citizenship immigration test to graduate. Mm-hmm. And that's very similar to what 30 plus other states have done. And there are some exceptions to 112 right now that we have written in, that are proposed in that bill. If you're a student that is exchange students and foreign nationals won't be required to take this particular test. And I've raised the question before in previous discussions that there are a lot of other students, though, that maybe should have an exception. Military personnel on active duty or veterans that have gone through their service. Maybe those people that are serving as a city councilman or a woman, or maybe those that are in a town government, or maybe on a school board, or maybe they serve as a student president of their high school, or whatever it may be, that have taken an oath to the Constitution. Those students, do they deserve exceptions? But more than that even, I'm wondering why we're taking this route rather than saying that as part of your general education requirements, you take a course in civics at college. And let the college have the course. Some states right now are designing their own test. And there's 14 states which require them to take a gen ed course. So there's no additional cost. It's just one of those gen ed courses you sign up for. And it might be fundamentals of American documents. That's another way of doing it. And it would save a lot of any costs because they're already paying for tuition for X number of credits to graduate. So that's some food for thought. I took some time to write some draft amending language up on that one, which would allow that to occur. And some states require both the taking the course and or taking a test like the immigration test. So you'd have your choice as a student. You could do it that way, or we could just say, you're going to take while you're in college a course. Representative Bricky.
So those students who have already taken the test and graduated from high school in New Hampshire, they would be exempt.
Exactly.
Yeah. My whole thought is that we are really trying all over the spectrum of education to do away with testing as we know what people know. I mean, even the EFA language or the homeschooling language talks about you don't have to take a test. You can do a portfolio kind of thing. So to ask them to take another test just seems to be kind of, I don't know. Will passing this test tell me how good a carpenter somebody's going to be? I don't think so. I don't know. I disagree with having students take another test as a way of saying, well, now you know it. And also, the other thing is, I don't believe that Representative Lynn said it's an online test, and then that's why.
That was Representative Moffett.
Moffett. I'm sorry. It was Moffett, not Lynn. Lynn was the previous bill.
Yeah.
Representative Moffett said it was an online test, so it wouldn't cost anything. I don't believe it is online, but I don't know that for sure. It doesn't make it free just because it's online. But anyway, so that was my thought. So plural, thoughts, plural.
Representative Burton and Representative Popovich.
I would point out that the average age of a student at the community college system is in the 27, 28. And if it's like my school, people go 30, 40, 50 years old. They've voted in hundreds of elections to try to make them take this test. By the way, this test does not, to me, do much for citizenship, because nowhere in here does it tell you should be involved. They have, the one I object to is name one war fought by the United States in the 1900s. And the correct answers are World War I, World War II, Korean War, Vietnam War, and Persian Gulf War.
All of them.
2 of them were declared, 3 of them weren't. Mm-hmm. And that was important because in Vietnam, I was, among other things, a justice, a lawyer, and if you desert in time of war, you get shot. If you're not at war, you go to prison. And I had a case like that, and I had to go all the way back to the Pentagon to find out if we were at war or not. And they said we weren't, and the guy that I charged was very relieved. But what concerns me is it doesn't tell you as an American citizen you should be actively involved in developing the issue. This is just a set of history. I mean, we were talking about just about 15 minutes ago about students not taking an interest in doing something about government and participating in government. So what if you can answer all these questions? That's my objection, and I don't think that I used to learn things from refugees from Russia about civics that I didn't know before, and I think that, and the last thing I would say is that at a 4-year school, the parents wait for the student to cross the stage and congratulate them. At a community college, the parents walk across the stage and the kids welcome them. Mm-hmm. And the last thing I would want to do, the hardest thing I ever did, was tell a student they couldn't walk. And if it's over something like this, and I'm telling a 45-year-old woman who's been in this country for 10 years and is a citizen, you can't walk because you haven't taken this test, would break my heart. Mm-hmm. And I think there's a big difference between the university student population and the community college population. And that's why I'm opposed to the bill. And that's my pitch.
Representative Popovich.
I just wanted to address the earlier comments on testing. I I believe it is essential for any educational system to have a clear way to assess the proficiency of its students and graduates. I think it's always an open discussion whether the best way to do it is standardized testing or through portfolios or through whatever methods. But I just want to make sure that we are all on the same page, that we are not talking about, eliminating proficiency assessment. We're just talking about the appropriate methods for every kid on how do we measure their proficiency. That's where I'm coming from. Thank you.
Representative Burton.
When you have an issue like that, and I'm not necessarily supporting it, you tend to say, okay, we're going to do civics across the curriculum. So that in every discipline, there's a piece of instruction on civics. How does history relate to civics? How does political science relate to history? How does business relate to history? And that's the way often issues like this are handled in accreditation standards. Not necessarily by taking a whole course. And so you get applied civics, if you will.
So in the research that I looked at between last time and now, I find that you can either count them on one hand, the number of states which use the immigration citizenship test, and I think it's only one that may. And Dakota is now the state board at the university system that has done that, not through statute. Most states which are doing it are administering their own test, which is a different one than the one with the number of questions which we have right now, and getting 7 out of 10 or turning into a memorization test, not necessarily reflecting how you apply the responsibilities and attend to the responsibilities of being a citizen in our country. And I think the people that are best equipped to ensure that all our college students have that. I came out of high school, of course, as we all did, and I'd taken U.S. history, and I'd taken everything I could in terms of geography and histories and all that. I still gained a lot more information when I was a little bit older and hopefully a little bit more mature. I wasn't a heck of a lot more mature. But when I went to college at UMaine and majored in history, and I took a lot more out from John Hackala, who was one of my professors, from Alice Stewart, who was actually the dean of maritime history throughout the country, and loved it. And I gained more. And I'm just wondering, I like the intent of the bill. The intent is try to ensure that our kids have an understanding of our foundation documents and how you take what's in those documents and apply them, regardless of which side of the fence you might be on. And by doing that, can we better do this rather than saying, oh, you passed the immigration test, so you've got it? Or would it be wise saying, we've got a history department, we got a government department in all our universities and in the community college system as well. Why not take one gen ed course that's dealing with fundamental American documents and do it that way? I did talk to one of our provosts about that. And he came on and said, wonderful. We'd enjoy kids taking more courses in our school. But we have professors that are just chafing at the bit to do this. And I think that'd be an exciting class to take, regardless whether I'm going off majoring in engineering or robotics or some form of medicine. This is part of being a citizen. So I'd like to see a little twist in this and keep the intent that we're trying to get kids students understanding their responsibilities as a citizen and applying them through maybe requiring that they take an undergraduate course and let the university figure out whether it's 1, 2, or 3 credits. It's up to them to ensure. 14 states are doing it right now. That's what those states are doing. When I went to Maine, it was a requirement back then. It was also a requirement when I went to Maine that you join ROTC for the first 2 years, which I got out of as soon as I could. And then graduated and enlisted of all things. So, but at any rate, that's my 2 cents on it. And I'd like to really, think about this, and maybe we could come back and look at this bill and maybe make it better. Representative Burton.
I just want to point out that there's a lot of co-curricular and extracurricular activities that go on campuses. And I think that's where students pick this up. I mean, when I got back from Vietnam, I co-led the anti-war demonstrations and got vilified by the union leader. But when I was an undergraduate at Bowdoin, I met Martin Luther King. He spoke and he asked if we wanted to have coffee with him afterwards. And it was an incredible day for me to have that happen. I think there should be activities on campus that promote civic engagement. And but it doesn't have to be a course. It could be.
I hope you met Joshua Chamberlain while you're at Bowdoin.
He was younger than I am.
Representative Bricky.
So I don't know that we're going to be able to wrap this up even in another meeting. Should this be a bill that we put to interim study?
I think we should have that discussion.
And we should probably do that pretty quick, because
Kathy,
Representative,
is it possible to get provost involved a little bit in terms of whether this be advantageous to require as a gen ed course that they take a course in American foundations?
I would think that would take a long time to.
Well, not necessarily. They have them right now.
Representative Propovich-Mueller has a meeting in 1 minute.
I would like to state for the record that I completely mixed up my calendars and I do not have a minute, or I would have ran away earlier. I appreciate your consideration and kindness.
We
sir.
actually do have a meeting.
Thank you.
We pushed back from 12:30.
That was supposed to start a half hour ago.
So, first let me say that the university system absolutely understands and appreciates the intent of the bill. We see it as our role to foster free speech and encourage civic life and activity in the community. I agree that taking the citizenship test is maybe not an indicator of whether or not we're being successful. So our campuses are working on revamping Gen Ed. I think Plymouth and Keene are actually finished. We're also having conversations. There's it's a collaborative, multi-state collaborative around civil discourse. And so we've had conversations about joining that multi-state collaborative, again, because this is an area we embrace and think part of our responsibility as institutions of higher learning. I will say my board and the presidents, we're probably all going to be in agreement that legislating graduation requirements becomes a bit of a slippery slope. So if we're going to have in state law what graduation requirements are, it kind of takes curriculum out of the hands of faculty, which that faculty develop and own the curriculum. It's part of the work that we do. So I can talk to the provost about how Gen Ed, how civic learning is integrated into the general education curriculum. Honestly, for all I know, it may already be. But I forget which member mentioned, oh, you need an answer. We can get back to you by November 10th, or when your next meeting is, of what we do currently within the curriculum. But I think we would probably still take exception to any graduation requirement that's legislated. Because again, what's next?
Representative Burton?
Quick question, Chancellor. I'm, in my dim memory, I think there's something in the accreditation standards that require you to the institution to show that they're creating civic-minded students.
I will absolutely follow up on that, Representative.
Are there further questions of the Chancellor?
I have some follow-up information, for the committee on HB 510
Yeah.
and on 112 or 212? I think it's 112.
112.
And so I will make sure that that information is in your hands in advance of your November 10th at 9 a.m.
Yeah.
Okay.
Yeah. Yes, Representative Popovich.
If we could maybe get it faster than that, because we need that information to work on language that then we need to agree on, and that does take time. So we'd appreciate it as quickly as possible. It should be all existing info. So if you could move that timeline forward quite a bit, maybe by next Monday, that would be great.
Understood.
Thank you.
Next Monday, that's after Halloween.
Not my problem.
Okay. Further, any other questions for, yes, Representative Brown?
I just want to point out that over the last 25 or so years I've been teaching at colleges, there's been a huge push to emphasize globalization in our classes. And I think a lot of students today have very little knowledge of U.S. history and civics,
Yeah.
being focused on these other topics. So something like this is needed.
Okay, thank you. Any further comments by the committee at this time? So what we're going to do is we're going to postpone any action on this. This will occur on the 10th at 9 o'clock. We will get together again. And we have several bills which we're looking forward to address at that time, 510 and this bill 112. So anything else for the good of the order? With that, we are adjourned. Thank you very much.
Thank you.
Yeah.